And we're live.
All right. Hey, everybody. Thanks so much for tuning in today. My name is Dana Gold. I am our Senior Counsel and Director of Education at the Government Accountability Project. Thanks so much for tuning in. We are today discussing the role of whistleblowers and promoting election integrity. The meeting is being recorded. So anyway, we are here discussing the role of whistleblowers in promoting election integrity and the launch of our new Democracy Protection Initiative. And this is a program, we are so excited, that is designed to support and protect employees who choose to blow the whistle on illegality and abuses of power aimed at undermining the election or sabotaging the peaceful transition of power if the electorate were to vote for change.
Good afternoon, everyone. My name is Aman Punjwani. I'm a Democracy Fellow at Government Accountability Project. And along with Dana, we lead the Democracy Protection Initiative. And on this live stream as well, we have a whole team available in the chat to answer any questions you may have. So feel free to type in anything you'd like to know about, and hopefully Dana and I can answer it in the progress of this live stream.
So people are still joining, but we're ready to get going. But again, feel free, as Aman said, add chats if we miss something, or if you want us to go over a certain point, and we'll try to wrap that up either at the end or midway. But again, I'm Dana Gold, Senior Counsel here at Government Accountability Project. And we are Government Accountability Project. For those of you who may not know, we are the nation's leading whistleblower protection and advocacy organization. We've been around for 40 years. We are a nonprofit, nonpartisan public interest organization, and we promote government and corporate accountability, so both. Our name hails back from the days of Daniel Ellsberg, so that is the source of our name. Our work is broader than that, but we promote accountability, institutional accountability, by protecting whistleblowers and ensuring their disclosures make a difference.
And for 40 years, we've provided two whistleblowers both legal and advocacy assistance, ranging from almost 8,000 employees of Conscious who we've helped. These employees, they come forward because they speak out on serious abuses of public trust. And we help them exercise their rights to report wrongdoing and hopefully make a difference with the information that they have. But also important to us is reform efforts. And using that very information, we share it through disclosures with the press, Congress, oversight agencies, public interest allies, and even the public. And our work in the reform areas, but also in disclosures in general, have ranged from issues related to climate science censorship, to safe food and drugs, to legal electronic surveillance of American citizens, to even immigration detention, and now the protection of our democracy.
So you may have seen our work recently in the news. We represent whistleblower Dawn Wooten, who is a nurse at the Irwin County Immigration Detention Center in Georgia. We are co-counseling that representation with our friends at Project South, an immigration advocacy justice organization in Georgia, but we helped Dawn blow the whistle on inadequate medical care and ICE detention, including hysterectomies on immigrant women performed without fully informed consent. So there's been a lot of profound attention to Dawn's disclosures, both about the medical problems, the failures to contain the spread of COVID-19, which were a big part of her disclosures, but also these, horrific problems about unwanted gynecological procedures without informed consent. But her story really is powerful. Even though she's not an election whistleblower, she really highlights the power of whistleblowers and their information to make a difference, and also to activate the gears of democracy. So her disclosures show the power of truth-telling. It catalyzed media reports, which then drove public awareness and outrage and action that fueled support of public interest organizations, as well as academics and scholars all around the country to look hard at what is happening in ICE detention and how we're treating immigrants. It's prompted congressional and agency investigations and oversight at a pace that is unusually and unprecedented, and it's driven legal actions and proposed legislative reforms, all within just a couple weeks. And that really shows the power of whistleblowers to make a difference through their disclosures and the power of a brave employee who chooses to speak up rather than stay silent. So this is a proven methodology. This is how Government Accountability Project has operated effectively, representing employees of Conscience for over 40 years on a whole range of issues, as Aman talked about, to both protect whistleblowers and to ensure their disclosures make a difference. It's really a two-prong two-prong issue, and that's really goes to the reasons whistleblowers or employees stay silent typically in the face of wrongdoing: fear of retaliation and fear that speaking up won't make a difference. And I like to say that that's what we address both of those issues. We protect the whistleblower, the person choosing to speak up, but ensuring that their information makes a difference. So we are now turning that same methodology towards election protection and democracy protection, and that is the whole power of the new Democracy Protection Initiative, which is taking the power of supporting whistleblowers towards providing employees who may witness abuses that may threaten election integrity and democracy itself with education and experience pro bono legal support.
And as Dana mentioned, inspired by Dawn Wooten herself, but all the other whistleblowers we've worked with over the last 40 years, the Democracy Protection Initiative is meant to respond to threats of democracy at the moment. As many of you may agree, our democracy is under attack and it requires urgent protection. On a daily basis, government officials and agencies are abusing their power of their office for political rather than the public interest. And the people who expose wrongdoing on a daily basis are constantly at risk of attack and retaliation just for speaking up with the truth. Whether it be an anti-science response to the COVID-19 pandemic, which has resulted in the silencing of public health workers and censoring information at the CDC, the FDA, and BARDA, or the current administration's use of law and order messaging that has been used to deploy DHS and DoD officers to quell citizens lawfully protesting an end to disproportionate state-sanctioned violence against Black, Indigenous, and people of color, or even the administration punishing Democrat-led cities by ramping up immigration arrests and threatening to withhold federal funds. The reality is our democracy is under attack. There are millions of infections and thousands of deaths within this country, overrunning hospitals, devastating our economy, causing massive unemployment, stymieing human and civil rights of millions of citizens, and now even disrupting the functioning of government itself. But lucky for us, in less than 30 days, citizens will take to the streets and cast a ballot to ensure that those who are elected represent the interests of the people rather than those elected themselves. But knowing that the administration is unwilling to address the continued threat of foreign interference in our elections, but continuing to also interfere in our postal service and spreading fear across the nation of voter fraud, unfounded as well, for mail-in ballots, we here at Government Accountability Project, but citizens across the nation must proactively work to restore confidence in our election process so as to protect the values and indeed the existence of truth, accountability, and a healthy democracy itself.
And so, of course, there are massive efforts underway to protect democracy. And this is our contribution to those massive efforts, because we have seen the power of disclosures of information by individuals who observe wrongdoing that can really fuel those efforts, because it's tangible evidence that we can mitigate, stop, address, and make sure that we are holding those who are responsible for wrongdoing or engaging in abuses accountable, so we can ensure free and fair elections. And we know that whistleblowers are effective. It's been true over the past 4 years. We have a whole bunch of examples of whistleblowers who have already exposed some of the most flagrant abuses of power that relate to the election process. So, just to refresh our memories, we have Russian attempts to interfere with state voter registration rolls in the 2016 presidential election through an email phishing operation, and a weakness that may continue to exist. We have the administration's effort to solicit foreign election interference by Ukraine targeted against a political rival in exchange for congressionally mandated aid. We have attempts by the politicized Department of Justice to advance the personal and political interests of the administration by intervening favorably for the administration's friends and unfavorably against foes. We have DHS's recent suppression of intelligence information regarding threats from violent white supremacy and Russian election interference. And as we've all are just so graphically aware, the administration's deliberate unwillingness to prepare for the coronavirus pandemic and instead directing funds towards dangerous and scientifically unsupported drug therapies and condemning the use of masks in spite of recommendations by its own public health experts. Not only has the censorship and disregard of public health information increased death and the economic toll, it had the consequences of voter suppression in Wisconsin and is undergirding baseless claims of voter fraud from mail-in ballots made necessary because of COVID. So we know that whistleblowers can catalyze action, oversight, and accountability through the power of truth. And the Democracy Protection Initiative is Government Accountability Project's attempt to respond to this current moment, which is just a moment like no other, by educating and supporting employees if they were to observe wrongdoing and choose to come forward to disclose the truth to protect our democracy.
We encourage everyone currently watching this live stream, but also who may watch this video later, and everyone in your network to actually visit the Democracy Protection Initiative's website at democracy.whistleblower.org, where we have much more information than we'll get into during this live stream. We have best practices for whistleblowers. We have extensive descriptions of whistleblower rights and protections for 9 audiences, including the Department of Justice, the Department of State, Homeland Security, Defense, United States Postal Service workers, White House employees, intelligence community, state and local election agencies and the workers within those agencies, and also public health agencies. And you can find all of this information at our website. Again, that is democracy.whistleblower.org. Also on that website, 2 audiences that are very important are journalists and advocacy organizations. And if you are a journalist or a member of an advocacy organization, we've included all the critical and time-sensitive information you need on that website for if a whistleblower were to come forward to you. Know that the legal landscape for whistleblowing is complicated and the risk of retaliation is very real. So journalists and advocacy organizations, we ask that you review this information, but also reach out to us at Government Accountability Project so that you don't inadvertently put an employee within one of these 9 audiences at risk if they were to come forward to you with information about wrongdoing. And important to note is that the information in this live stream, that on the website, and even some of the associated resources that will be put in the chat, they're not meant to be comprehensive and should not be construed as offering legal advice. But what it does offer to each of you is just basic guidance on whistleblower rights and protections before you reach out to the experienced attorneys at Government Accountability Project for more information and further assistance with your case.
So just as a reminder, if you just joined, my name is Dana Gold. I'm Senior Counsel at Government Accountability Project and our Director of Education. And with me is Aman Panjwani, our Democracy Fellow, and we're talking about Government Accountability Project's Democracy Protection Initiative at democracy.whistleblower.org and the important role whistleblowers play in promoting election integrity. And so I also just want to note, please leave questions in the comments or even offer comments, right? Like, whatever you're thinking, it'll be really useful for us as we tailor our work to support the mission that we're launching with this project, support employees of conscience, and make sure that questions are answered as we're offering this little live stream and future information. So I want to move a little bit about the process of whistleblowing and kind of talk about, again, with the caveat that this is not legal advice, it's not comprehensive, and that whistleblowing is very complicated. I'll talk a little bit as well, Aman, about kind of the legal landscape and contextualize some terms so we have an understanding and shared baseline. So we'll talk about the process of whistleblowing, what is a whistleblower in that legal landscape, as well as some best practices. So first, I just want to talk about what is a whistleblower. So a whistleblower is someone who exercises free speech rights to disclose abuses of public trust. The legal definition is a little bit more specific in general, at least in the United States. So we often look to the Whistleblower Protection Act, which is the big law that protects most, but not all, federal employees. And I share that. I share this definition because, one, it covers many of the audiences of that we're targeting in terms of the audiences of employees who may have information or witness information about abuses that threaten the election or democracy itself. But it also highlights several key points. So the Whistleblower Protection Act defines a whistleblower as an employee who discloses information that they reasonably believe evidences a violation of law, rule, or regulation, gross mismanagement, gross waste of funds, abuse of authority, or a substantial and specific danger to public health or safety. And so there are 3 points that are important, I think, to this definition. One, the categories of wrongdoing that are what we would call protected disclosures are significant. So this is not about someone maybe hoarding some extra post-it notes in the workplace. That would be not healthy for the workplace. It would be toxic and corrosive to a healthy workplace. But it doesn't rise to the level of seriousness that would impact the public interest, right? Whistleblowers are basically serving the public's interest because they are in the best position to promote legal compliance, to see problems and to mitigate risk and problems before they happen. So the what constitutes protected activity is our disclosures of information that rise to that level of seriousness. The other thing is that it covers employees. So whistleblower laws, not always, but the majority of whistleblower laws are typically structured as employment protections. And they give rights to employees to report wrongdoing free from retaliation, at least in theory. And you would have a right if you suffer retaliation. And the reason for this scheme is because not only are employees in the best position to witness misconduct firsthand, they have a front row view to where abuses could happen. They're also the most vulnerable to retaliation and reprisal professionally. So that's why that scheme has evolved that way. The other thing that I think is important to note, at least within the Whistleblower Protection Act language, which has been adopted by most of the other statutes that exist to provide whistleblower protection, is that the standard an employee has in disclosing information is a reasonable belief standard. So they don't have to prove the wrongdoing. They have to have a reasonable belief in that of evidence of the wrongdoing. And so that standard it's not irrefragable proof, which is actually how courts used to interpret it. It's a reasonable belief. So it's an objective standard. So this scheme, I think, packages what we talk about when we talk about whistleblowers, the largest category. There are exceptions, and that could be something that folks either want to ask questions about or that we could cover in a different video.
And a reminder to everyone tuning in, if you have any questions, feel free to add them to the chat where we'll see them. But we're focusing here on the Democracy Protection Initiative, which is focused on those 9 audiences I mentioned earlier, who we believe are critical to preserving the integrity of our election and ensuring a smooth transition of power if the electorate were to vote for change. And if there's one thing you take away from this live stream, know that it is that the whistleblower legal landscape is complicated. No matter where you work, before you can blow the whistle, you should understand the basics of federal and state level whistleblower protections and reach out to the experienced attorneys at Government Accountability Project who will be able to help you no matter what information you would like to disclose.
So piggybacking on that comment that it is incredibly complicated. There is no one law that protects all whistleblowers. It's not Title VII for whistleblowers. It's a patchwork of more than 60 federal statutes, numerous state and local laws that all can provide redress, which is good in that there may be a law that protects you. It also may be that you fall right through the cracks of the quilt of protections that exists. And each law has different remedies, different procedural steps, and different paths for enforcement. And it can be difficult to evaluate different legal options because it's really fact dependent. So each case presents a different set of facts, and you would assess, among other things, to figure out what kinds of legal protections you would have, or what type of worker one is. Are they a federal worker, a federal contractor? Are they a private, do they work in the corporate sector or the private sector? Which agencies are involved? What's the content of the disclosure, if something is classified or not? What is it evidence of an environmental problem or censorship or abuse of authority, or is it something about toxics or air safety? All of these different issues can matter about whether or not you have protection. Who is the disclosure made to? In what order? When was the disclosure made? What possible reprisal occurred? And when it occurred even can also matter. Statute limitations are radically different between laws, as are remedies. So not only can it be difficult to assess what your best or available legal remedies are, even once you choose a path and are pursuing that legal process, it is still very complicated, right? And in terms of ensuring that an employee is protected and supported during that process, meeting different timelines, filing things in the right place. Again, it can be very complicated. So I want to move, really quickly, I guess, more to that, the Whistleblower Protection Act that I mentioned earlier, which is that primary law that protects most federal employees. And so, I would say that this covers this covers many of the audiences that that are on the democracy.whistleblower.org website that we're targeting, who may be in the best position to witness misconduct. So, Department of Homeland Security, Department of State employees, civilian Department of Defense employees, public health officials, FEC employees, so Department of Justice employees. So basically, for those who aren't in the intelligence community, aren't enlisted folks or aren't in the state schemes, the Whistleblower Protection Act is probably the most ripe and available, if not, it's not the only, but it's probably the most dominant source of legal protection that folks have. And so again, as I mentioned before, the standard for whistleblowing for disclosure for protected disclosures for an employee is a violation of law, rule, or regulation, gross mismanagement, gross waste of funds, an abuse of authority, or a substantial and specific danger to public health and safety. And so one thing that's also really important to note is that under the Whistleblower Protection Enhancement Act that was passed in 2012, an employee can report censorship related to research, analysis, or technical information that is or will cause any of the above forms of misconduct. So, if scientific censorship will cause abuse of authority or a danger to public health and safety, or gross mismanagement or a gross waste of funds, scientific censorship is also now a protected class of information that whistleblowers can report. The other thing about the Whistleblower Protection Act that's important is that it gives federal employees the right to disclose information both internally to coworkers, managers, hotlines, or an agency IG. But it can also to Congress, they can also do it externally to Congress, agency enforcement offices, and absent statutory bars or classified information, so HIPAA, Privacy Act information, they can report also to the media or watchdog organizations, and those are considered also protected sources to receive whistleblower information. So I think there's one other piece that I think is really important about the Whistleblower Protection Act for folks to know, which is federal employees are also protected from retaliation if they testify or help another person with exercising their rights. So we've had a bunch of brave witnesses stand up in support of other whistleblowers who have made disclosures about wrongdoing, for instance, pressuring Ukraine to interfere in the 2020 election. We've had the other two areas that are super important to know about where federal employees are protected is if they cooperate with or disclose information to the Office of Special Counsel, the OSC, an agency IG, or Congress. So just blanket if they disclose information or cooperate with them, even if they're not the actual whistleblower, they're cooperating with an investigation or sharing information. And if they refuse to obey an order that would require them to violate a law, rule, or regulation. This is a slightly more treacherous right that is available to federal employees in terms of what the standard is of proof, but it is a codified right that again requires advice. We can't counsel enough how getting advice, ideally before one blows the whistle rather than after people suffer retaliation, is the right course of action. But this is an important piece, is that refusal to obey an illegal order. One other piece I want to mention is that duty speech is also protected under the Whistleblower Protection Enhancement Act. It fixed some case law. So even though there's a higher level of proof to show reprisal in those cases, there are employees who it's their job who are charged with investigating and disclosing wrongdoing as part of their job duties. So if they're a quality control inspector or part of an IG, office. So the proof to show reprisal may be higher, but duty speech is protected. And so the mechanism for exercising rights, federal employees can either go to the Office of Special Counsel and or the Merit Systems Protection Board. These are challenging and limited processes, but they can work. And we've had some encouraging support from the OSC. Or if a federal employee is part of a union, they can use an arbitration process through that union, but they have to choose the path. So that's, again, why it's really important to get advice, because if you have to, whichever one you choose, you're stuck with. I would also note that there are 12 million federal contractors out there. And so they work for the federal government, and they have their own separate scheme of protections under whistleblower protection laws that have been made permanent in the National Defense Authorization Act at 41 USC 4712. So it's the same standards apply, except for the right to report scientific censorship. So it's the same areas of protected disclosures of violation of law, rule, or regulation, abuse of authority, gross mismanagement, gross waste of funds, or substantial and specific danger to public health and safety. They also have to make disclosures to Congress, and IG, the Government Accountability Office, which is not the Government Accountability Project, it's the government audit organization. They can make disclosures to a federal employee grant or contract manager at the relevant agency, to the DOJ or other law enforcement bodies, to a court or grand jury, or to a management official or employee of the contractor who has responsibility to address the misconduct. The rights for federal contractors are actually far better than they are for federal employees, something that we are working on, because you can file a complaint of retaliation with an Office of Inspector General, and then you can remove it to federal court for a jury trial, whereas federal employees can't do that. That is something that we are working on. We are like leading the charge in improving and strengthening the rights for federal employees. And I think there's a way to take action and get involved with strengthening those rights of federal workers. So we encourage you to do that. But again, because the landscape is so complicated, it's just behooves you to go to our website, the democracy.whistleblower.org website, or Government Accountability Project's website as well, which is linked right to it, which has resources that can be helpful. And again, we offer pro bono representation, as we always have, but certainly right now we are amping up those services and that outreach to really support people who might want to come forward when this climate requires truth to make a difference.
And very quickly, we think there are a few more audiences that we want to touch off briefly. But again, if you want more information about any of these audiences, go to our website, democracy.whistleblower.org/rights, and you'll see all 9 audiences on the screen, and you just click one of them and all this information will be there. But quickly, another relevant audience is intelligence community employees or contractors who are also allowed to lawfully report wrongdoing and receive protection from retaliation. Know that the Intelligence Community Whistleblower Protection Act, which is different than the other acts that have already been mentioned, requires workers, whether they be case officers or analysts or even support staff, to follow very specific disclosure processes in order to obtain protections from retaliation. And the reason is disclosing classified information outside of this process is a criminal offense. There's no public interest exception or defense, even if the information that is disclosed exposes illegality. So it's very important that any intelligence worker considering blowing the whistle discuss their options for disclosures and the risks that they may face with one of the very few attorneys experienced in this area. And if you reach out to the experienced attorneys at Government Accountability Project, we can help you navigate the system, provide you the assistance you need, and bring in an entire team to actually craft a disclosure that actually protects you while getting the information out there.
And I would just, yes. So yes, all of that to the IC whistleblowers. They are super important, and it is very complicated to make sure that you are making disclosures in a way that's safe. Similarly, we mentioned Department of Defense civilians are covered by the Federal Whistleblower Protection Act that I was talking about earlier at some length. But actually, enlisted military service members are covered by the Military Whistleblower Protection Act. So if they're actually, enlisted, currently serving personnel. They are covered by the MWPA. They have the same rights to communicate information about a violation of law, rule, or regulation, gross mismanagement. So it's the same standard of what the content of the disclosure, but they have, again, like the IC process for intelligence community whistleblowers, there's a very specific process for reporting disclosures, as well as for lodging a claim of reprisal. Also, the process for investigating disclosures and claims of retaliation is exceedingly complex with specific timelines and processes. It can be very complicated. So this is, again, where expert support is actually really important for service members who observe wrongdoing or who suffer reprisal for lawfully reporting wrongdoing and need support. So we encourage you to reach out for advice.
Two more audiences that are very important to the current moment are USPS employees and state election workers, or even local level election workers. And these are the employees who will be on the ground, may witness threats to election integrity in front of them, specifically related to the voting process, whether it's absentee ballots or even voter registration. And they should know that while rights are limited, they are protected and have the ability to come forward. Specifically focusing on USPS employees, they're expressly exempt from the legal protection under the Whistleblower Protection Act. However, USPS employees should know that they have a strong union and they have the rights to blow the whistle free from retaliation under internal policies found in the USPS Employee and Labor Relationships Manual, along with some limited whistleblower rights under a patchwork of issue-specific laws, such as the Occupational Safety and Health Act. Unfortunately, some of these don't address the kinds of malfeasance that we've seen surface in the past few months and have limited remedies. But Dana can explain that they're still worthwhile to come forward for.
Yeah, we can still help postal workers make a difference. So not only do they have the support of their union, which has been terrific and super strong, whistleblowers don't come forward because they've checked out their legal rights and remedies. Like if that's all you have is your legal rights and remedies, nobody would speak up. People speak up because they have a sense of duty or they are concerned about the consequence of not speaking up, that they can't look at themselves in the mirror if they stay silent. That is why people speak up. And so it really is not necessarily just about whether or not you have adequate legal protections or how strong or weak they may be. We're really experienced in protecting us. We cannot promise that people don't suffer retaliation, but we can promise that disclosures can make a difference and that there are ways to insulate whistleblowers by rallying support around them through the power of their message. So it's focused on the message and not the messenger, and they can make a difference even despite weak legal rights. So, we would say the majority of whistleblowers that we have represented would blow the whistle again. They don't regret doing it. And I think that's a really important piece to understand. So just because the legal schemes may not be robust enough or adequate, that's how it's been for years and years and years, people still speak up because they can't stay silent, because it's the ethical and moral call that they have in terms of the oath that they signed as part of being a public servant. One thing I wanted to note, and I guess there's a great comment in the question that was asked in the feed about dealing with the potential deployment of poll watchers from perhaps DoD, National Guard, or DHS, because we saw that obviously in terms of clearing protesters at Lafayette Square for a photo op, deploying CBP and other agents to Portland, democratically held cities. And so this whole sense of perhaps using agents inappropriately for voter intimidation or suppression. So that's actually, I think, a real concern, exactly within the vision of the Democracy Protection Initiative. And so I think a great example is Mr. DeMarco, who testified in front of Congress at the National Guard, saying that they were deployed inappropriately against citizens who were exercising their constitutional rights of peaceful assembly, that was an inappropriate use. And he testified as a whistleblower in front of Congress and did exactly the right thing. So there are ways for employees of conscience who are being asked to either obey a legal order or to blow the whistle about that. These schemes of protections would protect them. them, and they should come forward if they're concerned about the inappropriate political deployment of agency resources counter to the mission in a way that is illegal or fundamentally subversive to undermining election integrity. I did want to really quickly, I know we're running over time here, and you guys have been so generous spending this time with us. But I just wanted to touch very quickly on the rights of state and local government election workers. And you won't be surprised by our comment of it's complicated. So as we've talked about this patchwork at the federal level, depending on what you blow the whistle on, similarly, each state has its own set of protections. Some are horrible and don't exist. Some are actually quite robust. Some are being created actually, have been created in the past several months. Just to shore up whistleblower protections, and certainly even since the pandemic, the rights of public health officials to speak out, for instance. Many states have improved their whistleblower protections available to employees. And so again, so it's another patchwork that's going to depend on what you're blowing the whistle on, what state you live in, the posture of your employment. And so again, there's no easy answer. It's all very fact specific. And so that's why, finding out in advance, ideally, about what the legal schemes are and to get advice about how to blow the whistle. And again, I think there are actually even more in the state and local regulations that apply, their municipal protections or state protections. It could be common law, could be available. To employees. Sometimes it can be very specific about who you're allowed to make disclosures to, almost like the Intelligence Community Whistleblower Protection Act, or that it's very specific about the timeline and who you can make a disclosure to. So it can be very harrowing and difficult to navigate for an employee. So again, there are protections, but they're complicated. So I think that would be the takeaway. There are protections, but it's complicated.
And just as important as knowing that there are protections and that it is complicated, again, at Government Accountability Project, we want to minimize the risk of retaliation to you. And one of the best ways to do that is ensure you take several precautions before coming forward. And we describe these at length at democracy.whistleblower.org/rights. But a few of them that are important to highlight here include creating a detailed paper trail and just saving any relevant documents you may have, such as meeting notes, memos, or emails. But once you have this paper trail or these notes, making sure second to keep it in a safe place and avoid being accused of stealing any documents that you can't take. Third, most importantly, make a plan and decide whether and when to blow the whistle internally or externally. And as Dana alluded to, come to us before blowing the whistle so that we can ensure you do it in the correct manner, ensuring you're following the process so that you are not facing retaliation down the road. And lastly, as we've emphasized over and over again, it is important to reach out to the experienced attorneys at Government Accountability Project, where we can help you, no matter what information you have. We're going to help you craft a strategy, which includes journalists, politicians, public interest organizations across the landscape, so that we can maximize that information you have and the impact of the disclosure itself, while minimizing the risk of retaliation to you. As Dana likes to say, solidarity is essential to both making a difference from blowing the whistle on misconduct and surviving the experience. We have 40 years of experience creating that solidarity around our clients, and we can help you do the same. And on our website, we've included all of these best practices, even more best practices related to external whistleblowing, which are very important. So we really encourage you to visit democracy.whistleblower.org to read up on all the information we have there.
So one final issue I want to address is whether a question we often get is whether whistleblowers can disclose information while maintaining their anonymity, or the value of that, because I think it's the hardest thing is the risk involved with speaking up. And the first move of those accused of wrongdoing is to attack the messenger. We've all seen that quite vividly rather than listen to the message. So we have a great book that we co-wrote with our friends at Peer and Pogo, Public Employees for Environmental Responsibility and Project on Government Oversight, which is Caught Between Conscience and Career, Expose Abuse Without Exposing Your Identity. It has great tips in there, and I think we'll throw that up in the comments. So anonymity, it's possible, but extremely difficult, and it can never be guaranteed. And if anyone does guarantee it, you should run away. It really can't be guaranteed. And the reason I want to talk about anonymity and why this is so important is because the information it's really tied to the whistleblower. Typically, if it's an employee source, right? Either because of the nature of the information, that it would be consistent with the person's job duties or the scope of their responsibilities that they would come in contact with that. So the pool of possible sources of that information, it would be finite. And also because whistleblowers typically raise concerns internally first, like overwhelmingly, often twice before they go outside. So the idea, and it may be just to a coworker, but the idea of being able to protect anonymity it's really doesn't take into account that most employees, they want to resolve the problem internally first. They don't want to go outside. So when you know that they've raised concerns internally first, or that the pool of possible sources of that information could be finite, it's really hard and risky to maintain anonymity. It is possible. And especially if the information is used in public ways or through strategic discussions with investigators, congressional, government, either congressional or other investigators, staffers, other whistleblowers or advocacy groups. Again, it can be very difficult, but it's also not necessarily the best strategy. I mean, if you can maintain it, and still be effective, that's important. But it can make a legal case actually more difficult, because if you do suffer retaliation, because it might be very easy to suss out from an employer's perspective who the source of the information was, you have to show that the employer had knowledge that you were the one blowing the whistle. And so if you try to maintain your anonymity, it can be a much harder case to show to meet that element in a legal case of knowledge, of employer knowledge. I think the other thing about whistleblowers who choose to make disclosures publicly, they can often preempt reprisal by putting an employer on notice that they are engaging in protected whistleblowing. So they're sending a shot across the bow that, if you take adverse action against me, I've engaged in protected whistleblowing and I'm giving you notice of that. And I have done so internally, and I've made disclosures to these protected entities. I think the other thing is when a whistleblower experiences solidarity with a team of allies, advocacy groups, journalists, other champions in Congress, faith leaders, a lawyer, focus can be more easily put on the wrongdoing rather than on the whistleblower, right? So it's focused on the wrongdoing exposed by the whistleblower, and that can undermine efforts to vilify the messenger. I think Dawn Wooten's situation was a great example of that, just really surrounded in support, focused on the nature of her disclosures, not on her. So I think it can really make a difference being the spokesperson, behind the credibility of this information. It can be a hero story. So I think that that's just an important piece, that the information, again, I think that's like one of the perhaps the most important takeaway, not just about this anonymity, but there's a person tied to this information, right? We want the information because we want to protect election integrity. We need free and fair elections. Our democracy is really fragile right now, and employees, like, truth is like this precious commodity. Whistleblowers have that. They need to be encouraged to speak up, but we can't ever forget that as much as we want their information, it's a brave act to be able to speak up. And so making sure that we don't inadvertently hurt them and that we honor their patriotism by speaking up to expose wrongdoing is really just baked into the DNA of our organization.
And with that, we're at the end of our live stream, but we want to end with a sense of urgency here at Government Accountability Project, but across the landscape. Other organizations believe, so do we, that truth matters now more than ever. And that's why whistleblowers are also needed to help protect election integrity and protect our democracy. And there's actually 5 ways you watching this live stream and those who may watch it soon afterwards can help. First off, you can share the link to the Democracy Protection Initiative with your networks. It's democracy.whistleblower.org. And just share that link with those workers who might be in positions to witness threats to election integrity and democracy, those 9 audiences I mentioned earlier and listed on our website. If you have any friends there, any coworkers, any colleagues, even acquaintances that you know are in those audiences, but also on the front lines of our elections and our democracy, just share the website. That will go a long way. Second, you can share a link to this talk with your network. We've given a lot of information in a brief manner, in a concise manner, and I think it would go a long way to help people know that it is complicated, but that they have options. You can also follow us on Facebook and Twitter and subscribe to our newsletter, where we are constantly sending out more information about current threats posed to our democracy, but also the rights and options that whistleblowers may have specifically related to the elections. Of course, donations are always welcome. It's important to know that we could not do this work without concerned citizens across the landscape actually funding the work itself. We offer pro bono representation to whistleblowers. We've done that for 40 years, almost 8,000 clients, and a dollar here and there goes a long way. And lastly, most importantly, be a champion for truth tellers in your own life by spreading the word that whistleblowers are essential to democracy in ensuring a free and fair elections. We can't do it without that sentiment being expressed. We need individuals to come forward to help protect our democracy, and just being a champion for truth tellers can make all the difference.
Absolutely. That culture shift where we value rather than vilify whistleblowers is profound in terms of creating norms where we value truth and ethics. And we all need that, perhaps more than we ever realized we needed it before. And so whistleblowers are great examples of that kind of heroism that we need around valuing truth telling. And so we're all here. We're standing ready to help employees of conscience whose disclosures can protect our fragile democracy. Thanks for watching and your commitment to accountable, functional government and the important role whistleblowers play in protecting all of our interests. Let me see. I'm not sure. I think that there's some other great comments in the chat. We've gone way over the time that we had planned on, but I think it was really important to share this and have this as a document that people can, a living document and archive that people can refer to. We'll take notes of the comments in the chat. Thank you for those. Feel free to continue those and weave those in to our education efforts going forward, because I do think that the complicated landscape that we focused on, is harrowing and weak and challenging, and we are working very hard on improving protections for whistleblowers. At the same time, we have seen consistently the power of whistleblowers to make a difference, and that is why we are offering our services in support of the most important issue of our time that could matter for every issue that we all care about. So thanks for supporting whistleblowers and the Democracy Protection Initiative, and we'll see you next time. Thanks so much.
Thank you, everyone. Take care.